In February of 2023, Warner Bros. Discovery filed a lawsuit against Paramount Global in the state of New York. The amount in dispute was approximately $500 million. The core of the argument, the single point on which the entire case turned, was the definition of a word. Specifically, whether 14 pieces of content produced for the Paramount Plus streaming platform qualified as episodes or as movies. One word in one contract. $500 million at stake. The entire streaming future of one of the longest-running animated series in American television history, suspended on the interpretation of a single noun in a licensing agreement that nobody outside of two corporate legal departments had ever read. South Park has been on the air since August 13, 1997. It has outlasted nearly every legal threat ever directed at it. Not by being careful, not by being measured, not by exercising restraint or moderating its targets, or listening to its lawyers when they said perhaps this time you should not, by being too fast, too legally protected, and too profitable to kill. South Park has been threatened, sued, and legally attacked more times than almost any show in television history. It has never lost. Before we go further, a quick note. If you enjoy long-form essays like this, subscribing genuinely helps the channel keep going. It costs nothing and takes a few seconds. Now, back to it. That record, that unbroken streak of legal survival spanning nearly 3 decades of continuous production, did not happen by accident. It did not happen because the show was lucky, or because its targets were careless, or because the American legal system is inherently favorable to provocateurs who happen to be funny. It happened because the show, from its earliest days, positioned itself inside a very specific legal framework. Satire, parody, commentary, the 3 words that form the armor plating of the First Amendment as it applies to entertainment media. And every single entity that has ever tried to crack that armor, from the Motion Picture Association of America to the Church of Scientology to the government of the People's Republic of China, has failed. Some of them lost money in the process. Some of them lost credibility. Some of them lost control of their own narrative entirely, watching helplessly as the thing they tried to suppress became more visible precisely because they tried to suppress it. But all of them lost. What follows is the full accounting. 10 legal battles arranged in the order they occurred, spanning 26 years of production. 10 times the show was threatened, challenged, suppressed, censored, banned, or dragged into a courtroom. 10 times it walked out the other side fundamentally unchanged. The show that airs today, in 2026, is the same show that premiered in 1997. More profitable, more culturally embedded, more legally tested, and therefore more legally fortified, but fundamentally the same in every way that matters. Same targets, same tone, same willingness to say what nobody else will say about anyone at any time, regardless of the consequences. The first of these battles did not take place in a courtroom at all. It took place in a series of screening rooms in Los Angeles, across 6 separate submissions to the Motion Picture Association of America, between the fall of 1998 and the early summer of 1999. The film in question was South Park, bigger, longer, and uncut. The problem was its rating. And the problem very nearly killed the project before it ever reached a single theater. To understand why this mattered, why a rating could have existential consequences for a film that was clearly destined for commercial success, you need to understand the economics of film distribution in the late 1990s. The MPAA rating system is technically voluntary. No studio is legally required to submit a film for classification. No law compels a filmmaker to accept the rating assigned to their work. But in practice, the system is compulsory because the infrastructure of American film distribution is built around it. The major theater chains, AMC, Regal, Cinemark, the companies that control the vast majority of screens in the United States, will not book films that are unrated or rated on C. 1-7, major retailers, Walmart, Target, Best Buy, the companies that in 1999 still controlled the majority of home video distribution, would not stock NC. 1-7 films on their shelves. Major newspapers and television networks would not run advertisements for NC. 1-7 films. The rating does not merely inform the consumer, it determines whether the consumer has access to the product at all. And NC 1-7 is not a warning. It is, in practical commercial terms, a death sentence. Paramount Pictures had financed South Park, bigger, longer, and uncut, with a production budget of approximately $21 million. This was not an art film. This was not an independent production financed by passionate investors willing to accept limited distribution. This was a major studio release backed by one of the largest entertainment conglomerates in the world, financed with the explicit expectation of wide commercial distribution across thousands of screens, marketed to the same 18 to 34 demographic that was already watching the television show on Comedy Central every Wednesday night. The show was averaging between 3 and 5 million viewers per episode in its second season. Paramount's bet was simple. Those viewers would pay $8 to $10 each to see the same characters on a larger screen with more extreme content than broadcast standards allowed. That bet only paid off with an R rating. An R meant 2,500 screens. It meant national marketing. It meant opening weekend box office projections that justified the investment. An NC-17 meant a few hundred screens in major cities, no national advertising, and a write-off. Paramount needed that R the way a patient needs a pulse. The MPAA did not agree. The film was submitted for classification in its initial cut in late 1998 and returned with an NC-17 designation. The specific objections, communicated to the filmmakers through the MPAA's standard process of written explanation, centered on the frequency and intensity of profanity, the nature of certain sexual references, the graphic violence in certain scenes, and the overall combination of all of these elements with animation. This last point was significant. Animation within the MPAA's classificatory framework carried an implicit association with content appropriate for children. The combination of animated characters speaking and doing things that would be extreme even in a live-action R-rated film triggered a heightened sensitivity in the ratings board. The board was concerned, explicitly or implicitly, that the animated format would attract younger viewers who would then be exposed to content well beyond their maturity level. An R-rated live-action film starring adults is clearly not for children by its very appearance. An R-rated animated film starring cartoon children occupies a more ambiguous space. Parker and Stone received the NC-17 and revised the film. They submitted a second cut, NC-17 again. They revised again, NC-17 again. This cycle repeated 5 times. 5 separate cuts of the film were screened for the ratings board across a period of approximately 5 months. And 5 times the board determined that the content exceeded the threshold for restricted adult viewing with parental guidance and entered the territory of content appropriate only for adults without exception. According to accounts from the production team given in interviews after the film's release, the MPAA's feedback was frustratingly vague. The board would indicate that the overall level of vulgarity was too high, but would not identify specific scenes or specific lines of dialogue that were causing the problem. They would not say, "Cut this scene and you will get your R." They would say the film is too vulgar and return it without specific actionable guidance. This vagueness made compliance difficult because the filmmakers did not know which specific elements to remove. At one point during this process, according to Parker and Stone's account in multiple interviews, the MPAA indicated a quantitative threshold. If the script contained 400 or more individual instances of profanity, the film would receive an NC-17 regardless of context or any other content consideration. 400 was apparently the magic number. Parker and Stone's response to this information was to count every profane word in their script with precision and ensure that the final cut contained exactly 399. They hit the number precisely. They treated the regulatory guideline not as a spirit to be respected, but as a letter to be gained. If 400 is the threshold, 399 is the product. This approach, this combination of precision and mockery, of compliance with the letter and contempt for the spirit, would characterize their relationship with authority for the next 27 years. There is an additional detail about this revision process that reveals something essential about Parker and Stone's psychology as creators. According to multiple interviews given after the film's release, particularly a detailed account Stone gave in 2006, each successive cut submitted to the MPAA was not tamer than the previous version. It was more extreme. Each time the MPAA returned the film with an NC-17, Parker and Stone revised it by adding content rather than removing it. Their reasoning, articulated clearly in retrospect, was that the MPAA's objections were arbitrary and inconsistent. They could not determine what specific elements were causing the NC-17 because the MPAA refused to tell them with specificity. If the board would not identify which specific elements were problematic, then the filmmakers had no rational basis for determining what to cut. So instead of cutting, they added. They pushed further. They made the subsequent submission more vulgar, more graphic, more extreme than the one before. Their calculation was that if they could not determine the line by approaching it carefully from below, they would determine it by crossing it so aggressively that the board would be forced to become specific. This strategy did not work exactly. The MPAA never became more specific. What it did was demonstrate that Parker and Stone were not going to self-moderate. The board was dealing with creators who responded to rejection with escalation. This created a dynamic in which the MPAA's continued resistance was not producing the desired behavioral modification. It was producing the opposite. The title of the film became a secondary battleground. The original working title was South Park: All Hell Breaks Loose. This title was rejected. The stated reason, according to Parker and Stone's account given in multiple interviews, was that the MPAA determined that an animated film could not contain the word hell in its title. An animated film, as if the word hell in the title of a film whose content included graphic sexual references, extreme violence, and 399 instances of profanity was the element that might confuse children about whether this was appropriate entertainment for them. The MPAA has disputed this account through its then spokesperson Richard Taylor, who stated that no film was submitted with that title and that the MPAA had no policy against the word hell in titles. The discrepancy between these accounts has never been resolved. Regardless of which version is accurate, the title was changed. Parker and Stone proposed an alternative: South Park. Bigger, longer, and uncut. The title was a phallic double entendre. It was designed as one. Parker and Stone have stated in interviews that they proposed it specifically as a joke aimed at the executives who would have to approve it. It was a test. Would anyone in the chain of approval, from the MPAA board to the Paramount marketing department to the theater chains that would display it on their marquees, recognize the innuendo and object? Nobody did. Nobody raised a concern. The title was approved through every level of review and appeared on billboards, in newspaper advertisements, on television spots, and on the lit marquees of family-oriented shopping mall multiplexes across the United States for the entire summer of 1999. The penis joke was 10 feet tall in Times Square, and nobody who could have stopped it noticed or cared. The sixth and final submission to the MPAA took place approximately 2 weeks before the film's scheduled release date of June 30th, 1999. By this point, the stakes were no longer abstract. Marketing materials had been produced and distributed, television advertising spots had been purchased and scheduled, theater chains had allocated screens and set showtimes, advance tickets had been sold, the entire commercial apparatus was in motion. A delay for further revision was not merely inconvenient, it was commercially catastrophic. Every week of delay meant lost advertising spend, rescheduled promotional appearances, and the risk that the cultural moment the film was designed to capitalize on would pass. The film was submitted for the 6th time and returned with an NC-17 for the 5th time. At this point, executive producer Scott Rudin intervened. Rudin was one of the most powerful producers in Hollywood, a figure known for his intensity, his influence, and his willingness to exercise that influence aggressively when projects were threatened. According to Matt Stone's account, Rudin called a senior Paramount executive, and in Stone's exact word, freaked out. The specific content of the conversation was not disclosed. The result was immediate. The MPAA reversed its decision. The following day, the film received an R rating. The cut that received the R was, according to Parker and Stone's consistent account across multiple interviews, identical to one of the earlier cuts that had received an NC-17. The same footage, the same scenes, the same 399 profanities, the same sexual references, the same violent imagery. Nothing in the content had changed. Only the external pressure had changed. A powerful producer had made his displeasure known to a major studio executive who had relationships with members of the ratings board. The next day, the content that was unacceptable became acceptable. The film that was NC-17 became R, without a single frame being altered. If this account is accurate, and it has been told consistently by both Parker and Stone across nearly 3 decades without variation or retraction, it reveals something fundamental about the MPAA's function in the entertainment industry. The rating was not determined by the content of the film. It was determined by the power dynamics surrounding the film. When the stakes were abstract, when the NC-17 was a theoretical problem for a future release that might or might not materialize, the board maintained its position. When the stakes became concrete, when a major studio's quarterly earnings projection was on the line, and a producer with significant industry relationships made clear that the outcome was unacceptable, the board found flexibility it had not previously demonstrated. The content did not change. The power dynamics did. Draw from that whatever conclusion you find appropriate. South Park, Bigger, Longer, and Uncut opened on June 30th, 1999 in 2,485 theaters across the United States and Canada. Its opening weekend gross was over $25 million. Its total domestic theatrical gross was approximately $52 million. Its worldwide gross was approximately $83 million. Against a production budget of $21 million, the film earned 4 times its cost. It received an Academy Award nomination for Best Original Song for the musical number Blame Canada, written by Trey Parker and Mark Scheiman. It was the first animated feature based on a television series to receive an Oscar nomination in any category since 1993. Major critics reviewed it favorably. Roger Ebert, one of the most influential film critics in America, awarded it 3.5 stars out of 4 and praised its satirical intelligence. The MPAA had spent approximately 6 months attempting to prevent this film from reaching a general audience. It had failed completely, and its failure had established a template that every subsequent confrontation would follow. An authority attempts to impose a constraint on South Park. The show's creators respond not with compliance, but with escalation. The constraint is eventually lifted not because the creators accommodated the authority's concerns, but because the commercial value of the product made suppression more expensive than release. The economics always win. The money always talks louder than the ratings board. This is not a cynical observation. It is simply the observable pattern. When you make something profitable enough, the entities that control its distribution will find ways to distribute it regardless of what content gatekeepers prefer. You might think that this experience, widely reported at the time and discussed extensively in entertainment industry publications, would teach subsequent adversaries something about the futility of trying to suppress this particular property. That people considering legal action against South Park might look at the MPAA experience and conclude that the cost of opposition exceeds the benefit. That potential plaintiffs might recognize the pattern and decline to participate in it. This was not the case. People and institutions continued to challenge the show. They continued to lose, and some of them became permanently associated with their failure in ways they could not have anticipated. The MPAA battle had established something important that every subsequent entry on this list confirms. When you challenge South Park, you provide South Park with a narrative. The MPAA fight became part of the film's marketing. It became part of its legend. People did not go to see South Park, bigger, longer, and uncut, solely because of the television show's popularity. They went because the film had been forbidden, because the ratings board had tried to suppress it 5 times, because a major studio had to fight to get it into theaters. The forbidden quality was itself the draw. The censorship attempt was the advertising, and every audience member who bought a ticket was, in some small way, participating in a statement about the futility of trying to prevent people from seeing something they want to see. This dynamic, the transformation of suppression attempts into marketing, would repeat with every subsequent confrontation. Each legal challenge made the show more interesting. Each threat made it more relevant. Each attempt to silence it gave it something to talk about. Parker and Stone understood this intuitively from the beginning. They understood that controversy is content. That opposition is oxygen. That every entity that moves against them is providing free labor for the next episode, the next interview, the next press cycle. The show does not merely survive its enemies, it puts them to work. The question then becomes, what kind of person or institution continues to challenge something that converts challenges into fuel? The answer is institutions that do not understand the dynamic, or that understand it but believe their particular power is sufficient. Over the next 27 years, both types would try, both types would fail, and both types would contribute, through their failure, to the growing body of evidence that challenging South Park is a self-defeating act regardless of the challenger's resources, regardless of the legal theory employed, and regardless of the jurisdiction in which the challenge is mounted. The second major confrontation began not with a legal filing but with a broadcast. On February 18, 1998, Comedy Central aired the 12th episode of the first season. The title was Mecha Streisand. The target was Barbra Streisand, one of the most successful and recognizable entertainers of the 20th century. And the consequences of that 22-minute episode would eventually contribute to naming a phenomenon that had existed throughout all of human history, but that nobody had yet identified with a single term. The premise of the episode is straightforward in the way that only South Park premises can be straightforward. Barbra Streisand comes to the town of South Park, Colorado, in search of a mystical artifact called the Diamond of Pantheos. She obtains the artifact from the children. Upon acquiring it, she transforms into a giant mechanical dinosaur approximately 200 feet tall, called Mecha Streisand. She attacks the town. She causes widespread destruction. She is opposed first by Sidney Poitier, the Academy Award-winning actor, who transforms into a giant turtle, and then by Robert Smith, the lead singer of the alternative rock band The Cure, who transforms into a giant moth. Smith ultimately defeats Mecha Streisand by picking her up and dropping her into an active volcano. The episode concludes with the townspeople declaring Robert Smith to be the greatest person who has ever lived. The end. The episode was watched by approximately 5.4 million viewers on its initial broadcast, which at the time represented a record high for the series and a remarkable number for any cable television program in 1998. Cable ratings in 1998 were measured differently than they are today, and 5.4 million viewers for a basic cable program represented cultural penetration far exceeding what the number alone might suggest to a modern audience accustomed to streaming metrics. The characterization of Streisand was deliberately, aggressively, and obviously unflattering. She was depicted as vain, power-hungry, aggressive, violent, and physically monstrous. The transformation into a mechanical dinosaur was not a metaphor. It was not a subtle commentary on celebrity ego. It was a literal transformation into a giant, destructive robot. And the episode made no effort whatsoever to present this as anything other than a direct personal attack on a specific living person. It was designed to provoke, it was designed to offend, it was designed to make Barbra Streisand angry. Parker and Stone have explained their reasoning in multiple interviews over the years. After Colorado passed Amendment 2 in 1992, a statewide ballot measure that prohibited local governments from enacting anti-discrimination protections for gay and lesbian residents, the amendment drew widespread national condemnation. Numerous public figures spoke against it. Many called for boycotts of Colorado. Among those who spoke most loudly was Barbra Streisand, who issued a public statement condemning not merely the amendment or the voters who supported it, but the entire state of Colorado and all of its citizens. She called for a total boycott of Colorado tourism and commerce. She stated publicly that she would never visit the state again and encouraged others to do the same. Parker and Stone were both Colorado natives. Parker grew up in Conifer, a small mountain community southwest of Denver. Stone grew up in Littleton, a suburb south of Denver. They had spent their entire childhoods and adolescences in the state that Streisand was condemning wholesale. They did not support Amendment 2. Their political views, to the extent they have been expressed publicly, tend toward libertarianism and social tolerance. But they resented a celebrity from Malibu condemning an entire state's population, including the residents who had voted against the amendment, including the residents who were too young to vote, including the residents who had campaigned actively for gay rights, as collectively deserving of economic punishment. The anger was specific and personal. It was the anger of people who feel their home has been unfairly maligned by someone who knows nothing about it. Streisand did not file a lawsuit over Mecha Streisand. There were no legal grounds for one. The episode was clearly satirical. No reasonable viewer could conclude that Barbra Streisand actually transforms into a mechanical dinosaur. The depiction was obviously fantastical, obviously exaggerated, and obviously presented as comedy rather than as factual reporting. A defamation claim would have required proof that the episode made false statements of fact that damaged her reputation. A statement cannot be false if no reasonable person would interpret it as factual. You cannot defame someone by claiming they turn into a giant robot because no one will believe the claim is literal. What Streisand did, according to contemporary reporting, was speak publicly against the show on multiple occasions. She expressed displeasure at the characterization. She criticized what she perceived as the show's general cruelty and its willingness to attack real people for entertainment. And Parker and Stone responded not by moderating their position, not by apologizing, not by moving on to other targets, but by doubling down. Streisand appeared in or was referenced in multiple subsequent episodes across multiple seasons. The character of Mecha Streisand returned in a later episode. Each iteration was, if anything, less flattering than the previous one. Each public statement Streisand made about the show became material for the next reference. And then, 5 years after Mecha Streisand aired, something happened that was not directly related to South Park, but which the show had, in a strange and almost prophetic way, been demonstrating since 1998. The dynamic the show had been exploiting, the principle that attacking something draws attention to it, that suppression generates amplification, that the attempt to silence creates the audience, played out on a much larger stage with much higher stakes. On May 31st, 2003, Barbra Streisand filed a $50 million lawsuit in Los Angeles Superior Court against photographer Kenneth Edelman and the website Pictopia.com. The legal theory was invasion of privacy. The subject of the dispute was a single aerial photograph. The photograph was designated Image 3850 in the California Coastal Records Project, a publicly funded initiative containing over 12,000 photographs of the California coastline, taken from helicopters at regular intervals, intended to document coastal erosion over time. Kenneth Edelman was a volunteer pilot and photographer who had contributed images to the project. Pictopia.com was the website hosting the image database. Image 3850 showed a stretch of Malibu coastline. Streisand's clifftop estate was visible in the frame. The photograph was not specifically of Streisand's home. It was one of 12,000 images of continuous coastline, each capturing a segment of several hundred meters. Her property happened to appear in one frame among thousands. The image was publicly available as part of a scientific coastal monitoring project. It was not tabloid photography. It was not taken by paparazzi. It was environmental documentation that incidentally included an expensive house. At the time Streisand filed her $50 million lawsuit seeking the image's removal, image 3850 had been downloaded from the Coastal Records Project website a total of 6 times. 6 total views. Among those 6 downloads, 2 were by Streisand's own legal team, who had accessed the image in the course of preparing the lawsuit. So, 4 people on Earth, other than Streisand's lawyers, had ever looked at this photograph. 4 people out of 6 billion knew it existed. The image was, for all practical purposes, invisible. It existed on a website visited almost exclusively by environmental scientists, coastal engineers, and government researchers. Nobody in the general public knew it was there. Nobody in the general public cared. The lawsuit changed that instantly. The filing was a matter of public record. Journalists who cover entertainment and celebrity news identified the filing and reported on it. The story was irresistible. One of the most famous women in the world was suing a volunteer photographer for $50 million over a photograph that almost nobody had ever seen. The story generated national media coverage. Within 1 month of the lawsuit's filing, image 3850 had been viewed over 420,000 times. Within a year, the number was in the millions. The photograph that Streisand was trying to make disappear became one of the most viewed photographs on the internet, specifically because she was trying to make it disappear. The lawsuit itself was the thing that made the photograph famous. Without the lawsuit, 4 people would have seen it. With the lawsuit, millions did. The case was eventually dismissed. Streisand was ordered to pay Adelman's legal fees of approximately $177,000. She had spent money and reputation trying to suppress an image that almost nobody had ever seen, and in doing so had ensured that millions of people would seek it out specifically because she did not want them to see it. The attempt at suppression was the advertisement. The censorship was the publicity. The silence was the amplifier. On January 5, 2005, technology journalist Mike Masnick published an article on the website TechDirt. The article discussed a different case entirely, one involving a Florida resort that had attempted to remove photographs of itself from a niche website. But Masnick used the Streisand incident as the defining example of the broader phenomenon. He gave it a name. He called it the Streisand effect. The name stuck immediately. It spread across technology publications, then mainstream media, then academic literature, then dictionaries. The Streisand effect is now recognized in multiple languages. It has been cited in hundreds of academic papers. It has been referenced in legal proceedings. It describes a dynamic so universal, so immediately recognizable across cultures and contexts, that people who have never heard of Barbra Streisand nonetheless understand the concept named after her. And South Park had been demonstrating this dynamic since February 18, 1998. 7 years before the term existed. Every time Streisand spoke against the show, she drew attention to it. Every time she expressed displeasure, she provided Parker and Stone with material for additional episodes about her. Every reference she made to the show in any public context was immediately reported by media outlets and immediately noticed by audiences who might not otherwise have been paying attention. The show's second legal confrontation was not a legal confrontation at all. It was a demonstration, an early, pure, almost laboratory-quality proof of concept for a dynamic that would define every subsequent challenge. And that dynamic is this. Attacking South Park generates attention for South Park. Attempting to silence South Park gives South Park material. Objecting to South Park invites South Park to object to you more loudly and more specifically. The show does not merely survive opposition. It metabolizes opposition. It converts hostility into content. It feeds on the energy of its adversaries. This is not an accident of its format or a coincidence of its cultural moment. It is the foundational logic of its entire creative process. Every enemy becomes an episode. Every lawsuit becomes a joke. Every ban becomes a badge of honor. This is why everyone on this list ultimately failed. And this is why everyone who comes after them will fail as well. Think about that for a moment. Think about what it means strategically. If you are an entity considering action against South Park, you must factor into your decision the certainty that your action will generate attention for the show, not the possibility. The certainty every previous adversary has generated attention, every single one. Without exception, the MPAA fight made the film more desirable. Streisand's objections made the show more interesting. Scientology's corporate maneuvering made the episode more famous. There is no version of opposing South Park that does not simultaneously promote South Park. The promotion is not a side effect. It is a structural inevitability. It is built into the dynamics of media attention in an era when controversy drives clicks, shares, and engagement. This means that the rational calculation for any potential adversary is not merely will I win this legal battle, but can I win this legal battle in a way that does not simultaneously benefit my opponent? And the answer to that second question is always no. There is no way to challenge South Park that does not benefit South Park. Even a successful legal challenge, if one could be achieved, would generate the kind of media attention that drives subscriptions, viewership, and cultural relevance. Victory itself would be a form of defeat, because the attention generated by the victory would exceed any damage the victory inflicted. This is why the show has no natural predator. A natural predator is an entity that can consume its prey without strengthening the prey in the process. South Park has no such entity because every form of consumption, every form of attack, every form of challenge strengthens it. It is the apex of its ecosystem not because it is the most powerful entity in entertainment, but because no other entity can attack it without making it stronger. It exists in a position of ecological dominance not through force, but through the structural impossibility of being successfully predated. The third major confrontation accelerated this dynamic to a scale that none of the participants could have anticipated. It did not begin with a lawsuit filing. It began with a broadcast. On November 16, 2005, Comedy Central aired the 12th episode of the 9th season. The target was not a single individual. It was an organization, specifically the Church of Scientology. And the fallout from that 22-minute episode would ripple outward across years, involving one of the world's most commercially valuable movie stars. One of the show's founding voice actors, a multinational religious organization with a documented history of aggressive litigation against critics, and a resignation letter sent on behalf of a man who is physically incapable of writing or approving it. The episode opens with Stan Marsh, one of the 4 central child characters, agreeing to take a personality test at a local Scientology center. The test is a parody of the actual auditing process used by real Scientology centers to recruit new members. Stan's results are extraordinary. He scores at an unprecedented level on his Thetan measurement. The Scientology officials in the episode determined that Stan is the reincarnation of L. Ron Hubbard, the founder of Scientology who died in 1986. News spreads, Tom Cruise, depicted as a character, arrives at Stan's house to meet the new incarnation of Hubbard. Stan, unimpressed, tells Cruise that he is not that good an actor, and that other performers, specifically John Travolta and Leonardo DiCaprio, are more talented. Cruise responds by walking into Stan's closet and refusing to come out. For the remainder of the episode, multiple characters attempt to coax Cruise out of the closet. The double meaning, the connection between the physical act of being in a closet and the metaphorical concept of being in the closet regarding one's sexuality, is not subtle. The episode does not attempt subtlety. Subtlety is not the objective. Additionally, and more significantly from a legal perspective, the episode contains a lengthy animated sequence explaining the foundational theology of Scientology. This sequence describes the story of Xenu, a galactic overlord who, according to Scientology's upper-level teachings, transported billions of alien beings to Earth 75 million years ago, arranged them around volcanoes, and destroyed them with hydrogen bombs. The souls of these beings, called Thetans, attach themselves to living humans and are the source of all psychological and spiritual problems. This narrative is considered classified information within the Church of Scientology. It is normally revealed only to members who have achieved the level of operating Thetan III, a process that typically requires years of participation and hundreds of thousands of dollars in course fees and donations. The episode presents this material with a banner displayed at the bottom of the screen reading, "This is what Scientologists actually believe." The Church of Scientology has, throughout its history, maintained an aggressive legal posture toward critics and perceived enemies. The organization has filed hundreds of lawsuits over its existence. Former members and investigative journalists have documented a strategy sometimes referred to as fair game, in which critics of the church are subjected to sustained legal, personal, and professional harassment. The strategy uses the legal system not to obtain favorable verdicts, but to impose costs, filing multiple simultaneous lawsuits in different jurisdictions, demanding extensive and expensive discovery, deposing critics and their family members, prolonging proceedings through procedural motions, and making the experience of being sued so exhausting and expensive that critics cease their criticism regardless of the legal merits. The point is not to win. The point is to make losing too expensive for the other side. Given this well-documented history, the expectation after Trapped in the Closet aired was that the church would file suit. It was widely assumed within the entertainment industry that a lawsuit was forthcoming. Comedy Central's legal department reportedly prepared for litigation. Parker and Stone have stated that they expected to be sued. The Church of Scientology did not file suit. According to reporting from investigative journalists who cover the organization, including accounts from former high-ranking members who participated in the discussions, the church's internal deliberations about legal action against Comedy Central centered on a single problem: discovery. In American civil litigation, both parties are entitled to demand relevant documents and communications from the opposing party through the discovery process. If the church sued Comedy Central for defamation, asserting that the episode made false and damaging claims about Scientology's beliefs and practices, Comedy Central's defense attorneys would be entitled to demand the church's internal communications about those beliefs and practices. They would be entitled to depose church officials about the accuracy of the episode's characterizations. They would be entitled to demand financial records, membership records, communications about Tom Cruise, communications about the episode itself, and any other documents relevant to the claims at issue. The Church of Scientology is famously secretive about its internal operations, its financial structure, its membership numbers, and particularly the content of its upper-level theological materials. A lawsuit against Comedy Central would have required opening these materials to hostile opposing counsel. The cost of the lawsuit, measured not in legal fees but in institutional exposure, was determined to exceed the cost of tolerating the episode. The church chose silence over discovery. It chose to absorb the mockery rather than risk having its internal documents subpoenaed and entered into the public record of a court proceeding. But that did not mean nothing happened. Tom Cruise, one of the most commercially valuable actors in the world in 2005 and 2006, took action through a different mechanism. Not legal, but corporate. Cruise's next film at the time was Mission Impossible 3, scheduled for release in May of 2006. The film was produced by Paramount Pictures. Paramount Pictures was owned by Viacom. Viacom also owned Comedy Central. The corporate structure, the fact that the same parent company owned both the network that aired South Park and the studio that needed Cruise's cooperation to market a $200 million action film, created leverage that a lawsuit could not have created. According to multiple reports published in major entertainment industry publications, corroborated by statements Parker and Stone made in subsequent interviews, and confirmed by executives at Comedy Central and Viacom, who spoke on background to reporters, Cruise communicated through intermediaries that he would not participate in publicity for Mission Impossible 3, unless Viacom ensured that Trapped in the Closet would not be re-aired. The episode had been scheduled for a standard rerun on March 15, 2006. Reruns are normal, popular episodes are regularly re-aired. This rerun was pulled. On March 14, Comedy Central announced that the scheduled rerun had been replaced. In its place, the network would air an episode described as a tribute to the character of Chef, a reference to Isaac Hayes, whose departure from the show had been announced the previous day. The timing of Isaac Hayes' departure is central to understanding the full scope of this confrontation. Hayes had voiced the character of Chef since the show's pilot episode. He had been part of the show for 9 years. On March 13, 2006, one day before the rerun cancellation was announced and 2 days before the rerun was scheduled to air, a statement was released in Hayes' name. The statement announced that Hayes was leaving South Park because of what he called the show's religious intolerance. He objected, the statement said, to the show's treatment of religious belief. Parker and Stone responded publicly the same day. Their response was pointed. They observed that Hayes had been content to collect a paycheck from the show for 9 years while it mocked Christianity, Judaism, Islam, Buddhism, Hinduism, Mormonism, Catholicism, and virtually every other organized religion on Earth. He had never expressed an objection during any of those 9 years. He had laughed along with jokes about Jesus, about Moses, about Muhammad, about Buddha. The only religious group whose mockery troubled him was his own. The only faith he sought to protect from satire was the faith to which he personally belonged. Parker and Stone characterized this as a double standard. They characterized it bluntly. But here is what nobody knew in March of 2006. What nobody could have known because the information was not available. In January of 2006, approximately 2 months before the resignation statement was released in his name, Isaac Hayes had suffered a severe stroke. The stroke left him with significant cognitive and motor impairments. He could not speak clearly. His son, Isaac Hayes III, has stated that his father had to relearn basic functions, including playing the piano. He was hospitalized and then in recovery. He was not making professional decisions. He was not approving public statements. He was not in any meaningful sense capable of quitting anything. But everyone around Isaac Hayes at that time was a member of the Church of Scientology. His personal assistants were Scientologists. His professional handlers were Scientologists. The people who had access to his professional communications, his agent contacts, his public statements were Scientologists. His son has stated clearly and publicly that his father did not quit South Park. Someone quit on his behalf. Someone drafted a resignation statement, released it to the media under his name, and ended his 9-year association with the show without his knowledge, without his consent, and while he was physically incapable of objecting or even understanding what was happening. Isaac Hayes III made this information public in a post on the social media platform X in July of 2025. His statement was unequivocal. For over 14 years, people have speculated about why my father left South Park. I am here to set the record straight. My dad did not quit South Park. Scientology did. After the episode Trapped in the Closet aired in 2005, my father suffered a stroke just a few weeks later. He was in no position to resign. Scientology quit for him without his knowledge, using his name. The full picture, then, is this. The Church of Scientology could not sue South Park because Discovery would expose its secrets. So it deployed Tom Cruise's commercial leverage to suppress a rerun, and it removed the show's veteran cast member by drafting a resignation in his name while he lay in a hospital recovering from a stroke. These were not legal actions. They were institutional maneuvers, corporate pressure, and organizational control over a vulnerable individual. Neither succeeded in their ultimate aim. The episode eventually re-aired. It remains available on all streaming platforms. It is one of the most discussed episodes in the show's history. The controversy around it drove viewership higher, not lower. And the revelation about Hayes' involuntary departure, coming 19 years after the fact, only deepened public sympathy for the show and deepened public skepticism toward the organization that tried to suppress it. Parker and Stone's formal response to the affair was delivered through their attorney in the form of a public statement. The statement addressed the rerun cancellation and the broader controversy. It was signed by Trey Parker and Matt Stone. Below their signatures, they included a self-description. They identified themselves as servants of the Dark Lord Xenu. Xenu, as described above, is the central figure in Scientology's classified upper-level theology. His name and story are materials that the church charges hundreds of thousands of dollars to reveal and goes to extraordinary lengths to keep secret. By placing Xenu's name in a formal legal communication, Parker and Stone were accomplishing several things simultaneously. They were demonstrating that they possessed the information the church considered its most closely guarded secret. They were mocking the church's claim that the information was valuable by treating it casually. They were signaling that they had no intention of being intimidated, and they were providing the church with evidence that any future lawsuit would immediately bring Xenu into the public court record. It was a dare. It was a threat disguised as a joke, the same way everything Parker and Stone do is a threat disguised as a joke. If the Scientology confrontation revealed the show's resilience against institutional pressure from a powerful organization, the fourth entry reveals something different. It reveals the show's ability to contribute to the legal system itself, to create language and concepts that lawyers and judges actually use, to participate in the discourse about law from within the discourse about comedy. And unlike every other entry on this list, it does not involve a threat against South Park. It involves South Park making something that became part of the legal world permanently. On October 7th, 1998, Comedy Central aired the 14th episode of the second season. The title was Chef Aid. The episode tells the story of Chef discovering that a major pop hit performed by Alanis Morissette is actually a song he wrote 20 years earlier. The record company that released the hit acknowledges privately that Chef is the true author but refuses to credit him publicly. When Chef attempts to assert his authorship and obtain proper credit and compensation, the record company does not merely deny his claim. It goes on offense. It sues him. The entity that committed the theft sues the victim of the theft, using its vastly superior financial resources and legal infrastructure to transform the victim into the defendant. This inversion, this use of the legal system as a weapon by the powerful against the powerless, was Parker and Stone's commentary on the music industry of the late 1990s. The specific inspiration was the pattern of major record labels using their legal resources to crush artists who challenged their contractual arrangements. But the episode's lasting contribution to American culture came not from its music industry satire, but from its courtroom satire. The lawyer representing the record company, a character modeled explicitly on attorney Johnny Cochran, deploys a legal argument that the episode calls the Chewbacca defense. The argument proceeds as follows. Ladies and gentlemen of the jury, Chewbacca is a Wookiee from the planet Kashyyyk, but Chewbacca lives on the planet Endor. Now, think about that for a moment. That does not make sense. Why would a Wookiee, an 8-foot-tall Wookiee, want to live on Endor with a bunch of 2-foot-tall Ewoks? That does not make sense. But more importantly, you have to ask yourself, what does this have to do with this case? Nothing. Ladies and gentlemen, it has nothing to do with this case. It does not make sense. If Chewbacca lives on Endor, you must acquit. The argument is transparently, deliberately, obviously nonsensical. It makes no logical connection between the subject matter of the argument and the case at hand. It does not attempt to make a logical connection. Its purpose is not to persuade through logic, but to confuse through irrelevance. The jury is so bewildered by the apparent confidence of a man making an obviously absurd argument that they cannot think clearly enough to rule against his client. The strategy works. The jury rules against Chef. The Chewbacca defense succeeds. The target of the parody was Johnny Cochran's closing argument in the 1995 O.J. Simpson murder trial. Cochran's famous line, "If it does not fit, you must acquit," referred to a demonstration in which Simpson attempted to put on a leather glove found at the crime scene that appeared too small for his hand. Legal scholars and commentators criticized the argument as a piece of emotional manipulation that exploited a physical demonstration to distract the jury from the broader forensic evidence. Parker and Stone took this criticism and pushed it to its logical extreme. If focusing the jury's attention on a glove can win an acquittal in a murder trial, why not focus it on a Wookiee? The underlying rhetorical mechanism is identical. Distraction, confusion. The introduction of an emotionally or cognitively engaging irrelevancy that prevents rational analysis of the actual evidence. Nobody sued South Park over Chef Aid. No legal action was threatened. Johnny Cochran, who was still alive at the time, did not file a defamation claim. But something remarkable happened in the years following the episode's broadcast. The term Chewbacca defense entered the legal profession, not as a joke, as working terminology. Legal commentators, writing in law reviews and legal publications, began using Chewbacca defense as a recognized shorthand for a specific category of courtroom strategy, one in which an advocate deliberately introduces irrelevant, confusing, or nonsensical arguments in order to prevent the trier of fact from focusing on the actual evidence and reaching a rational conclusion. The term has appeared in published law review articles. It has been referenced in briefs filed in actual courtroom proceedings. It has been discussed in legal education contexts, used by professors to illustrate a specific rhetorical technique, a term invented for a 22-minute animated comedy, conceived in a writer's room in Los Angeles by two men who are not lawyers and have no legal training, became part of the working vocabulary of the American legal system. It describes something that practicing attorneys encounter in courtrooms. It describes something that judges must identify and rule against. It describes something real, and it was created by a cartoon. This matters because it illustrates a dimension of South Park's relationship to the legal system that every other entry on this list only partially captures. The show does not merely survive contact with the legal system, it contributes to the legal system. It provides language, it provides frameworks, it provides analytical tools that actual legal professionals find useful in their actual work. The show is not merely a defendant in legal disputes, it is a participant in legal discourse. And a participant in the discourse is considerably harder to suppress than a mere target of the discourse. You do not sue the entity that is helping you understand how lawsuits work. If the Chewbacca defense was a fictional lawsuit that became part of real legal language, the fifth entry is a real lawsuit that became part of legal precedent. The case is Brownmark Films versus Viacom International Inc., filed in the United States District Court for the Eastern District of Wisconsin. It is the most legally significant lawsuit ever filed against South Park, not because it posed the greatest threat, but because its resolution established principles that extend far beyond any single television show. On April 2, 2008, Comedy Central aired Season 12, Episode 4. The title was Canada on Strike. The episode's plot involves the nation of Canada going on strike against the rest of the world, demanding more money from the internet. Within this broader satirical premise, a subplot follows the character of Butters Stotch. Butters creates an internet video. In the video, Butters performs a song and dance routine titled, What in the Butt? The video is a direct, deliberate, acknowledged, shot-for-shot recreation of a real viral YouTube video of the same name. The original video was performed by an artist named Samuel, produced by a company called Brownmark Films based in Milwaukee, Wisconsin, and uploaded to YouTube in 2007. By the time South Park recreated it, the original had accumulated millions of views and become one of the most recognizable viral videos of the early YouTube era. The recreation in South Park was not subtle, not partial, not merely inspired by the original. It reproduced the visual framing, the choreography, the camera angles, the set design, the costume choices, and the musical structure of the original. Butters was placed in Samuel's position. The recreation was presented within the context of an episode satirizing the culture of viral internet celebrity and the essential emptiness of online fame as a measure of actual creative accomplishment. For approximately 2.5 years after the episode aired, nothing happened legally. Then, on November 12, 2010, Brownmark Films filed a copyright infringement lawsuit in the United States District Court for the Eastern District of Wisconsin. The defendants named were Viacom International Inc., MTV Networks, and South Park Studios. The claim was the most straightforward copyright claim imaginable. The plaintiff owned a copyrighted video. The defendants had reproduced that copyrighted video in substantial and recognizable detail without the plaintiff's permission and broadcast the reproduction to millions of viewers on a commercial television network, generating advertising revenue from the reproduction. The similarity was not disputed, it was not deniable, it was not a matter of interpretation. It was a frame-by-frame recreation admitted by all parties. The defense was fair use, codified in Section 107 of the Copyright Act of 1976. The defense argued that the recreation, despite its visual fidelity to the original, was transformative, that it did not merely reproduce the original work but placed it in a new context that altered its meaning. That the purpose of the reproduction was not to exploit the commercial value of the original video, not to substitute for it in the marketplace, not to enable viewers to experience the original without seeking it out, but to comment on the cultural phenomenon that the original represented. The video was reproduced in order to be analyzed. It was recreated in order to be critiqued. It was shown in order to be discussed. And that analytical, critical, commentary-based purpose transformed the reproduction from infringement into protected speech. On July 7, 2011, approximately 8 months after the lawsuit was filed, United States District Judge J.P. Stapmuller issued a ruling that startled copyright attorneys nationwide. He granted the defendant's motion to dismiss, not a motion for summary judgment, a motion to dismiss. The distinction between these two procedural mechanisms is crucial for understanding the significance of the ruling. In most copyright cases, the question of fair use is considered a mixed question of fact and law. It involves a four-factor balancing test: the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use on the market for the original work. These factors typically require factual inquiry. They typically require evidence. They typically require, at minimum, the exchange of information through discovery and the opportunity for both parties to present arguments supported by evidence. Summary judgment, the earlier of the two possible dispositive motions, occurs after discovery. It asks whether, given all the evidence gathered, any reasonable jury could find for the plaintiff. A motion to dismiss occurs before any of that. It occurs before discovery, before depositions, before document exchange, before evidence is presented. A motion to dismiss asks the court to determine that even if every factual assertion in the plaintiff's complaint is assumed to be true, the plaintiff has not stated a legal claim that could succeed. It is the lowest possible bar for a defendant to clear and the highest possible achievement, winning a case before it even becomes a case. Judge Stapmuller determined that South Park's use of what in the butt was so obviously, so clearly, so unambiguously fair use that no reasonable jury could ever find otherwise, regardless of what evidence might be presented. The transformation was evident on the face of the work. The commentary purpose was obvious from the context. The market substitution was non-existent because nobody watches a South Park episode as a replacement for watching the original YouTube video. The case was over before it started. The plaintiffs spent money filing a lawsuit and received nothing in return except a published opinion explaining in detail why their claim had no legal merit. The precedent established by Brownmark extends far beyond South Park. The ruling confirmed that transformation does not require substantial alteration of the copied material. You can reproduce something nearly exactly, frame by frame, shot by shot, line for line, and still qualify for fair use protection if the context of the reproduction constitutes commentary on the original. Transformation can occur through recontextualization alone. The thing copied does not need to be changed. The meaning around it does. By placing an identical reproduction in a satirical framework, the meaning of the reproduction shifts, even if the pixels do not. For South Park, Brownmark was legal vindication of its entire creative methodology. The show has always worked by taking real cultural artifacts, real videos, real statements, real events, real commercial products, real people, and placing them in a new context that exposes them to comedic analysis. The Brownmark ruling confirmed that this method is not merely tolerable, it is protected. It is endorsed by the federal courts. It is fair use as a matter of law, so clear that it does not even require a trial to confirm. Think about what that means in practical terms. Think about what it means for the show's day-to-day creative process. Every week, the writers sit in a room in Los Angeles and decide what to put in the next episode. Every week, they must decide what real people to reference, what real events to incorporate, what real cultural artifacts to reproduce or parody, or directly recreate within the show's fictional framework. Before Brown Mark, there was always a theoretical question hovering over that process. Could this specific reproduction of this specific piece of copyrighted material trigger a legal challenge that would survive preliminary motions? Could a plaintiff with sufficient resources sustain a claim long enough to impose meaningful costs? After Brown Mark, that question was answered definitively by a published federal court opinion. The answer was no. Not if the reproduction serves a commentary purpose. Not if the context transforms the meaning. Not if the show is doing what it has always done, which is taking the raw material of contemporary culture and subjecting it to satirical analysis within a fictional narrative framework. The Brown Mark ruling did not merely protect one episode about one viral video. It protected an entire creative methodology. It protected the fundamental approach that defines how South Park is made. It established that the practice of appropriating and recontextualizing copyrighted material, the practice that forms the core of the show's satirical method, is constitutionally shielded as a matter of law. Future plaintiffs with similar claims would have to contend with published precedent explicitly establishing that this exact type of use qualifies as fair use on a motion to dismiss. The barrier for any future copyright challenge was raised from merely difficult to functionally impossible. You would need to find a case in which South Park reproduced copyrighted material without any commentary purpose whatsoever, without any transformative context, purely and exclusively to exploit the commercial value of the original work in a manner that competed directly with the original in its marketplace. Given the structure of the show, given that every reproduction is embedded within satirical narrative and transformed by comedic context, that hypothetical case simply does not exist. It cannot exist because the show's format does not allow it. Everything in South Park is satire. Everything is commentary. Everything is transformed by the context of the show itself. There is no scenario in which copyrighted material appears on South Park without being subjected to the show's analytical lens, because that lens is the show. This matters because it explains something observable about the chronology of legal challenges against the show after 2011. The frequency of copyright-based claims decreased noticeably after the Brown Mark opinion was published. Not because the show stopped incorporating copyrighted material. It continued to reference, reproduce, parody, and appropriate cultural artifacts with exactly the same frequency and boldness it had always demonstrated. The decrease occurred because potential plaintiffs and their attorneys could now review published federal court precedent demonstrating conclusively that such claims would fail at the earliest possible stage of litigation. The ruling functioned not merely as a victory in one case, but as a deterrent against all future cases sharing the same legal theory. Every copyright attorney in the country who reviewed the Brown Mark opinion arrived at the same professional conclusion. Filing a copyright infringement claim against South Park based on the show's incorporation of copyrighted material for satirical purposes is not a viable legal strategy. It will fail. It will fail early. It will fail on a motion to dismiss, and the plaintiff will bear the costs of that failure without any possibility of recovery. The show's legal position by 2011, 13 years into its run, was therefore stronger than it had been at any previous point. Constitutional protection established through practice and precedent. Fair use protection confirmed by published federal court opinion. Corporate backing providing effectively unlimited defense resources. A production cycle too fast for preventive legal action. And a track record of defeating challengers so consistent that future challengers were increasingly deterred from even making the attempt. The fortress was not merely built, it had been tested, and every test had proven it sound. You might reasonably wonder whether there exists any force on Earth powerful enough to overcome all of these protections, whether there is a scenario in which the First Amendment, the fair use doctrine, the speed of the production cycle, and the corporate resources of a major media conglomerate are all insufficient. The answer is yes. That scenario occurred in April of 2010, and its consequences represent the only permanent suppression in the show's entire 29-year history. On April 14, 2010, Comedy Central aired the 200th episode of South Park. The episode was titled simply 200. It was conceived as a landmark celebration of the show's longevity, a milestone few animated series reach. Its premise brought back nearly every celebrity and public figure the show had ever mocked across its 13-year existence. Tom Cruise, Barbra Streisand, Rob Reiner, Sally Struthers, Paris Hilton, Michael Jefferson, dozens of others. The celebrities form a class. They threaten to file a lawsuit against the town of South Park unless the town meets a single demand. They want the town to produce Muhammad, the Prophet of Islam. Their reasoning within the logic of the episode is that Muhammad possesses a unique power, the power of not being ridiculed. Nobody mocks Muhammad. The celebrities want that power for themselves. They want to be immune from satire the way Muhammad appears to be immune from satire. so they demand to meet him, hoping to obtain or absorb his immunity. This was not the first time South Park had depicted Muhammad. On July 4, 2001, the show aired the third episode of Season 5, titled Super Best Friends. In that episode, Muhammad is depicted openly and without any form of censorship. He appears as a member of a superhero team comprising major religious figures: Jesus, Buddha, Moses, Krishna, Joseph Smith, and Muhammad himself. Muhammad has fire powers in the episode. He fights alongside the other religious figures. He speaks dialogue. He is visible on screen, unobscured, uncensored. The episode aired without incident. No controversy followed. No threats were made. No complaints were registered. Nobody cared. In 2001, depicting Muhammad in an animated comedy was not considered provocative. It was considered unremarkable. By 2010, the context had changed dramatically. In September of 2005, the Danish newspaper Jyllands-Posten published 12 editorial cartoons depicting Muhammad. The cartoons provoked international outrage. Embassies were attacked. Boycotts were organized. Over 200 people died in protests across the Muslim world. Death threats were issued against the cartoonists and the newspaper's editors. In 2007, Swedish artist Lars Vilks produced drawings depicting Muhammad, prompting similar threats. The understanding of what constituted acceptable commentary about Islam's central figure had shifted enormously in the 9 years between Super Best Friends and episodes 200 and 201. Between the airing of episode 200 on April 14th and the airing of episode 201 on April 21, 2010, a website called revolutionmuslim.com published a post. The website was operated by a small group of radical Islamists based in New York City. The post included a photograph of Theo van Gogh. Theo van Gogh was a Dutch filmmaker, the great-grandnephew of painter Vincent van Gogh, who had produced a short film called Submission about the treatment of women in Islam. On November 2, 2004, Van Gogh was shot 8 times and then stabbed by Mohamed Bouyeri on an Amsterdam street. Bouyeri then attempted to decapitate Van Gogh and pinned a note to his body with a knife, threatening further violence. The RevolutionMuslim.com post displayed a photograph of Van Gogh's body and stated that Matt Stone and Trey Parker would probably end up like Theo Van Gogh for airing this show. The post provided the street address of South Park Studios in Los Angeles, California. It provided the street address of Comedy Central's headquarters in New York City. The implication was explicit, not merely implicit, explicit. This is what happens to people who depict Muhammad. Here are the addresses where these particular people can be found. The New York Police Department dispatched additional security personnel to Comedy Central's offices at 1515 Broadway in Midtown Manhattan. Parker and Stone were advised by law enforcement to increase their personal security. The FBI opened a criminal investigation into RevolutionMuslim.com and its operators. 2 members of the group, Zachary Adam Chesser and Jesse Curtis Morton, were subsequently arrested and convicted on federal charges related to making threats and soliciting violence. Chesser received a 25-year federal prison sentence. Morton received an 11.5-year sentence. These were not empty threats from anonymous internet commenters. These were communications that the United States Department of Justice determined constituted criminal solicitation of violence, serious enough to warrant prosecution and decades of incarceration. When episode 201 aired on April 21, 2010, its content had been substantially altered. The alterations were made by Comedy Central. They were not requested by Parker and Stone. They were not approved by Parker and Stone. The network acted unilaterally, imposing censorship on the episode after the creators had submitted their final cut and before it aired. Every reference to the name Muhammad in the episode's audio was replaced by a sustained bleep tone. The character's visual depiction, which had been included uncensored in the version Parker and Stone submitted, was covered by a large black rectangle bearing the word censored. But the network's censorship extended far beyond Muhammad. The final sequence of the episode consisted of 3 consecutive monologues. Kyle delivers a speech about intimidation and the mechanics by which threats of violence achieve the suppression of ideas. Jesus delivers a speech. Santa Claus delivers a speech. The content of these speeches did not reference Muhammad. It did not reference Islam specifically. It was a broader statement about the principle at stake, that if you can silence speech through fear, then any sufficiently credible threat can control public discourse. Comedy Central bleeped almost the entirety of all 3 monologues. The audience heard nothing but a continuous, uninterrupted bleep tone for several minutes. The moral of the episode, the philosophical conclusion of the 2-part storyline, the statement the creators intended to make about fear and speech and the relationship between violence and silence, was rendered completely inaudible. The audience saw the characters' mouths moving. They heard nothing. After the episode aired, the South Park Studios website posted an unusual notice. The notice stated that Comedy Central had inserted numerous additional bleeps throughout the episode after Parker and Stone submitted their final approved cut. The notice made clear that the censorship was not the creators' choice. It was imposed on them. Comedy Central subsequently confirmed this. A network spokesperson stated that the censorship decisions were made in consultation with the network's security advisors and were based on the assessment of risk. Episodes 200 and 201 have never re-aired on Comedy Central in any form. They were not included in the South Park library when HBO Max acquired streaming rights in 2020. They are not available on Paramount+. They are not available for purchase on any digital platform. They are not available on any physical media release produced after 2010. They are, as of 2026, permanently unavailable through any legal commercial channel. They are the only episodes in the show's 29-year history to be permanently removed from distribution. The only ones out of over 327 episodes that cannot be legally viewed. This is the exception. This is the one-time suppression worked, not because a court ordered it. No court was involved in litigation. No litigation occurred, not because a regulatory body made a determination. No regulator acted. Not because the content lacked legal protection. It was satire. It was commentary. It was clearly protected speech under the First Amendment. The suppression succeeded because the threat was not legal. It was physical. It was an explicit promise of murder, backed by the recent precedent of an actual murder committed under exactly the same circumstances. And the corporate entity that owned the distribution rights to the episodes determined that the risk of violence, however small in probability, created a liability that no legal department, no security team, and no insurance underwriter was willing to accept. Parker and Stone have addressed this incident infrequently in the years since. When they have, their position has been consistent. They are unhappy with the censorship. They believe the episodes should be available. They believe the content is protected speech and that its suppression represents exactly the capitulation to fear that the episodes themselves warned against. But they also acknowledge that the decision was not theirs to make. The episodes are owned, in terms of distribution rights, by the network and the streaming platforms that license them. Those entities made a risk calculation and determined that silence was safer than speech. Parker and Stone do not agree with that calculation. They accept that it was not their calculation to make. This entry is important because it defines the boundary. It establishes the one scenario in which South Park's legal armor fails. That scenario is not legal challenge, it is not corporate pressure, it is not regulatory action, it is not financial threat. It is the threat of physical violence sufficiently credible that risk-averse corporate entities choose suppression over exposure. That is the only weapon that has ever worked against this show, and even it worked only partially. The episodes exist. The content is known. Uncensored versions have circulated online. The ideas in the bleeped speeches have been transcribed and discussed publicly. The suppression prevented official distribution. It did not prevent the ideas from entering public discourse. Even the only successful attack on South Park was only partially successful. But even in the context of that partial success, something important happened that confirms the broader pattern. The two men who made the threats, Zachary Adam Chesser and Jesse Curtis Morton, were not merely investigated. They were arrested, prosecuted, convicted, and sentenced to a combined 36.5 years in federal prison. The American legal system, which could not prevent the censorship because the censorship was a corporate decision rather than a legal one, responded instead by imposing devastating criminal penalties on the people who created the conditions for the censorship. The system could not protect the episodes in real time, but it destroyed the adversaries after the fact. The message communicated to any future would-be threatener was unambiguous. If you threaten South Park with violence, you will spend decades in a federal penitentiary. This is the system working as designed, even in the one case where it appeared to fail. The episodes were censored, but the censors were not the people who made the threats. The censors were corporate executives making risk calculations. And the people who actually made the threats, the people whose actions created the conditions for the corporate censorship decision, were permanently removed from society. The legal system did not prevent the harm, but it ensured that attempting to cause such harm carries a cost so extreme that no rational actor would repeat the attempt. The deterrent is not against censorship. It is against the specific mechanism that caused the censorship. And that mechanism, threats of violence, is now priced at 25 years per participant. There is a question that remains from this incident, and it is a question the show itself has never definitively answered. Will episodes 200 and 201 ever be officially released in their uncensored form? Parker and Stone have expressed the desire for them to be available. The legal landscape has shifted since 2010. The people who made the threats are in prison. Revolution Muslim no longer exists. The specific threat that motivated the censorship has been neutralized. But the corporate decision-making process that led to the censorship operates on institutional memory and risk aversion, rather than on current threat assessment. Once content has been classified as high risk, reclassifying it requires someone at the corporate level to actively choose to accept responsibility for any consequences. And in corporate environments, nobody is rewarded for accepting risk. People are rewarded for avoiding risk. So the episodes remain suppressed, not because the threat persists, but because the institutional incentive to maintain the status quo is stronger than the institutional incentive to change it. Nobody at Paramount will be promoted for releasing episodes 200 and 201. But someone at Paramount could be fired if those episodes are released and something bad happens. The asymmetry of incentives guarantees continued suppression regardless of the actual current threat level. This is the residual damage, not to the show's creative trajectory, which was unaffected, not to its revenue, which was unaffected, not to its cultural position, which, if anything, was strengthened by the martyrdom narrative. The residual damage is to two specific episodes that remain locked in a corporate vault because no individual executive has sufficient incentive to unlock them. It is damage not from the original threat, but from the corporate response to that threat, a response that is ossified into permanent policy through institutional inertia rather than through ongoing deliberation. The seventh legal confrontation, chronologically, is the least significant of the 10. It posed no credible threat to the show, it resulted in no lasting changes, it attracted media attention primarily because of its novelty rather than its legal merit. But it is instructive as a demonstration of what happens when an individual without institutional backing, without substantial resources, and without a compelling factual basis attempts to use the legal system against a target that is defended by the full resources of a major media corporation. On October 2, 2012, a man named Xavier Wardlaw filed a complaint in the United States District Court for the Eastern District of Pennsylvania. The defendants named were South Park Studios, Trey Parker, and Matt Stone. The cause of action was copyright infringement. Wardlaw claimed that a character called the Lollipop King, which appeared in South Park's 2007 three-part Imagination Land episode arc, was plagiarized from his own prior creation. Wardlaw identified himself as the creator of a children's program concept called The Lollipop Forest, featuring a character he called Big Bad Lollipop. He had registered a copyright for this work with the United States Copyright Office on March 7, 2006. The Imagination Land episodes aired on Comedy Central on October 17th, October 24th, and October 31st, 2007. The Lollipop King character appeared in these episodes as one of dozens, perhaps hundreds, of imaginary characters populating a shared fantasy realm. The realm was populated by characters from every imaginable fictional source: fairy tales, mythology, science fiction, horror, children's television, comic books. Among this vast assemblage of fictional beings was one called the Lollipop King. In the Imagination Land episodes, the Lollipop King is a minor character. He does not drive the plot. He does not have a central role. He appears in ensemble scenes. He is present during sequences involving violence and chaos, including being physically attacked by a Star Wars stormtrooper and witnessing other characters in distress. Wardlaw alleged that this use of a character similar to his own creation constituted both copyright infringement and defamation of his intellectual property, because his wholesome creation had been placed in an unwholesome context. On January 15, 2013, Wardlaw filed an amended complaint that added Viacom and MTV networks to the list of defendants. The case generated coverage in entertainment media outlets, though the coverage was notably skeptical. Multiple publications observed that Wardlaw's creation appeared to exist primarily as a YouTube video uploaded shortly before the lawsuit was filed. The video bore production hallmarks suggesting recent creation rather than development predating 2006. The copyright registration date provided a legal baseline, but the actual evidence of a fully developed prior work was thin. The legal arguments against Wardlaw's claim were numerous and substantial. The Imagination Land episodes were clearly parody, placing familiar character archetypes in a satirical context. The Lollipop King character bore only generic similarity to Wardlaw's claimed creation, both being royal characters associated with candy. Generic character concepts cannot be copyrighted. Only specific creative expression can be copyrighted. A king made of candy is an idea. Copyright does not protect ideas, it protects specific expressions of ideas. The specific expression of the Lollipop King in South Park, his visual design, his dialogue, his narrative function, was created by South Park's production team and bore only the most superficial resemblance to Wardlaw's claimed prior work. The case was resolved without going to trial. No public record of a damages payment exists. No changes were made to the Imagination Land episodes. They remain available in their original unaltered form on all distribution platforms. The Lollipop King continues to appear exactly as he always has. The most likely resolution, given the absence of any visible consequence, is that the case was dismissed or settled on terms that required nothing of the defendants other than the cessation of legal proceedings. The lesson is this: without institutional resources, without a compelling factual foundation, without a legal theory that accounts for parity and fair use, an individual plaintiff cannot successfully challenge South Park through the courts. The corporate defense apparatus, the legal teams maintained by Paramount and its predecessors, exist specifically to dispose of claims like this efficiently and without concession. The system is designed for it. The resources are allocated for it, and claims that lack legal merit are resolved without altering the show in any way. If the Lollipop King lawsuit was the least consequential legal challenge South Park has faced, the 8th entry represents the most expensive dispute ever associated with the show. And unlike every other entry on this list, it does not involve an external party attempting to challenge, suppress, or alter the show's content. It involves two of the largest media corporations in the world fighting over who gets to profit from the show. The show is not the defendant, it is the prize. And the amount at stake exceeds what most people earn in several thousand lifetimes. To understand this dispute, you need to understand the streaming wars of 2019 through 2023. During this period, every major entertainment conglomerate in the world was either launching or had recently launched a direct-to-consumer streaming platform. The strategic logic was simple. Rather than licensing content to third parties and allowing those third parties to build subscriber bases using your content, build your own platform and use your own content to attract subscribers directly. Disney launched Disney+. Warner launched HBO Max. NBC Universal launched Peacock. Viacom CBS launched Paramount+. Apple launched Apple TV+. The competition for content that could drive subscriptions was ferocious. In this environment, library content, shows with established audiences who would seek them out specifically, was enormously valuable. A subscriber who joins a platform specifically because it carries South Park is a subscriber that platform retains as long as South Park remains available. The show functions as a permanent draw, a reason to maintain a subscription month after month. This makes it fundamentally different from a new original series that generates subscriptions during its release window and then fades. South Park's library, stretching back to 1997 with hundreds of episodes available for repeat viewing, represents a permanent asset. In 2019, Warner Media, the company that then owned HBO, signed a deal to acquire exclusive streaming rights to South Park for its HBO Max platform. The deal was worth approximately $500 million. The terms, as later revealed through the litigation, provided HBO Max with the complete existing library of 23 seasons comprising over 300 episodes, plus an additional 3 new seasons of 10 episodes each, for a total of 30 new episodes to be produced and delivered during the multi-year term of the agreement. $500 million for the library plus 30 new episodes. That was the deal. That was what was paid. Then, in 2020, the world changed. The COVID-19 pandemic shut down production across the entertainment industry globally. Film and television sets closed. Writers' rooms went remote. Production timelines were disrupted at every level. South Park's production schedule was affected along with everything else. Season 24, which was supposed to be the first of the 3 new seasons covered by the HBO Max deal, produced only 2 episodes. These aired as special pandemic-focused 1-hour specials rather than as a traditional season of standard-length episodes. Season 25 followed in 2022 and consisted of 6 episodes. Between the 2 seasons, HBO Max received a total of 14 episodes rather than the 20 expected from 2 seasons, and nothing from a potential 3rd season. 14 delivered, 30 contracted. A gap of 16 episodes. Meanwhile, separately in August of 2021, Viacom CBS announced a new deal with Trey Parker and Matt Stone. The financial terms of this deal were reported at approximately $900 million, later clarified as $935 million over 6 years, running from 2022 through 2027. Under this agreement, Parker and Stone would produce 14 made-for-streaming movies, also described as extended-length specials or events, for exclusive distribution on the Paramount Plus platform. These specials would use the South Park characters, the South Park setting, and be produced by the South Park creative team. They would also continue to produce regular seasons of South Park for Comedy Central broadcast. Warner Bros. Discovery, which completed its merger with Warner Media in April of 2022, looked at these facts and reached a conclusion. The conclusion was that it had been cheated. The logic went like this. Paramount had contractually committed to delivering 30 new episodes to HBO Max. Only 14 had been delivered. At approximately the same time, Paramount had struck a deal with the same creators to produce 14 pieces of South Park content for Paramount's own streaming platform. The math was suggestive. 14 episodes missing from the HBO Max deal. 14 specials produced for the competing platform. Same creators, same characters, same universe, different label, different platform, different price. Warner Bros. Discovery filed suit in February of 2023. The complaint alleged breach of contract, fraudulent inducement, and what the filing described as verbal trickery. The core argument was that Paramount had deliberately relabeled episodes as movies in order to divert content away from HBO Max, where it belonged under the 2019 deal, and toward Paramount Plus, where it served Paramount's own commercial interests. The episodes that should have been delivered to HBO Max were instead produced under the label of streaming movies and sent to a competing platform. Same product, different packaging, different destination. Paramount's response, filed in April of 2023, took a different position. Paramount alleged that it had delivered everything the contract required. The pandemic had affected production across the entire industry. Reduced episode counts were a universal reality, not a deliberate breach. The made-for-streaming movies were a separate creative initiative. They were not episodes in different packaging. They were genuinely different creative works. Longer format, different narrative structure, different production process, different artistic intention. And furthermore, Paramount alleged, Warner Bros. Discovery owed $52 million in licensing fees that it had contractually committed to pay and had withheld. 2 payments of $26 million each. Paramount counterclaimed for that amount. In November of 2023, a judge issued a mixed ruling on pretrial motions. Some of Warner Bros. Discovery's claims were dismissed as legally insufficient. Others were allowed to proceed toward trial. The court found that the contractual language defining what constituted an episode versus what constituted a movie was ambiguous enough that reasonable people could disagree about its meaning. The question of whether a 60-minute South Park special produced for streaming constitutes an episode of the series or a standalone film was not definitively answered by the contract's text. It was a genuine factual dispute requiring further proceedings to resolve. This case is unlike anything else in South Park's legal history. Nobody alleged that the show was offensive, nobody claimed it was defamatory, nobody asserted that it violated anyone's rights or infringed anyone's safety. 2 corporations were fighting over money, very large amounts of money. $500 million from one direction, $900 million from another. $52 million in counterclaims. The show's content was not in question. The show's quality was not in question. The show's right to exist was never at issue. The only question was, who gets to sell it, and how much do they owe each other for the privilege? Think about what $500 million means in this context. Think about what $900 million means. These are not merely large numbers. They are numbers that transform the legal landscape around the show. When Warner Bros. Discovery sued Paramount for $500 million over South Park streaming rights, that lawsuit was simultaneously a statement about the show's value. Every headline about the lawsuit communicated to the public that South Park is worth $500 million to a single distribution partner. That information enters the consciousness of every potential future adversary. Every person or organization that might consider suing South Park must now reckon with the fact that the show is backed by entities willing to spend hundreds of millions of dollars to acquire it. Those entities will defend their investment with proportional force. Suing South Park is not merely suing a television show, it is threatening the value of a $500 million asset owned by a publicly traded corporation with a legal obligation to protect shareholder value. The WBD versus Paramount case also reveals something about the show's economic architecture that earlier entries only hinted at. The show has multiple revenue streams that are independently valuable. There is the Comedy Central broadcast license. There is the streaming library license. There are the made-for-streaming specials. There is merchandising. There is the Broadway show. There are international distribution agreements. No single adversary can threaten all of these streams simultaneously. Even if one stream were somehow disrupted by legal action, the others would continue generating revenue that would fund the legal defense of the disrupted stream. The show's economics are diversified in a way that makes comprehensive financial threat impossible. You cannot starve something with this many independent revenue sources. And consider the implications for Parker and Stone personally. Their combined net worth, derived primarily from South Park's revenues across nearly 3 decades, places them among the wealthiest creators in the entertainment industry. They have no financial vulnerability. They cannot be impoverished by legal costs. They cannot be bankrupted by an adverse judgment. They cannot be pressured into settlement by the accumulating expense of litigation. They have, in Stone's own public characterization of their financial position, what he called a certain kind of freedom that comes from being beyond the reach of financial threat. That freedom is not merely psychological, it is strategic. A creator who cannot be financially damaged by litigation cannot be deterred by the threat of litigation. The entire purpose of strategic lawsuits, the imposition of costs sufficient to deter the target's behavior, is neutralized when the target has resources that exceed any possible cost. The Warner Bros. Discovery lawsuit is therefore not merely the most expensive dispute associated with South Park. It is a demonstration of the show's transition from a protected creative work to an economic institution. An institution around which multiple corporate strategies are built. An institution whose existence is factored into the valuations of publicly traded companies. An institution whose survival is guaranteed not by any single legal protection, but by the collective self-interest of every entity that profits from it. The show has become so economically embedded in the entertainment industry's financial structure that its suppression would constitute a destruction of value on a scale that no rational actor would authorize. This is the final form of legal protection, not constitutional, not temporal, not corporate in the narrow sense of having a well-funded legal department. Economic. The show has become too valuable for anyone to allow it to die. It has achieved a form of immortality not through artistic merit alone, but through the accumulation of financial dependencies. It will continue to exist because too many powerful entities need it to exist. Their need guarantees its survival more reliably than any constitutional provision or court ruling ever could. And this, perhaps more than anything else on this list, explains why South Park is functionally unkillable. It is too valuable. When two of the largest media companies in the world go to war over streaming rights to a show, that show has achieved something beyond legal protection. It has achieved economic criticality. It has become a revenue stream that multiple corporate boards depend upon. Multiple shareholder presentations cite it as a strategic asset. You cannot suppress something that 3 or 4 publicly traded companies count as a material contributor to their financial performance. The legal protection is real and important. But the economic protection is what makes the legal protection ironclad. Nobody with the resources to mount a credible legal challenge against South Park has the economic incentive to do so, because everyone with those resources is profiting from the show's existence. The 9th entry on this list is different from the others. It is not a single incident. It is a structural analysis. It is the answer to the question that every preceding entry raises. How does this keep happening? How does a show survive this many challenges from this many different types of adversary across this many years? What is the mechanism? What are its components? And can you see it clearly enough to understand why it works? The answer has 4 layers. Each layer is necessary. No single layer would be sufficient alone. But together they create an integrated defense system that has proven effectively impenetrable across nearly 3 decades of testing. The first layer is constitutional. The First Amendment to the United States Constitution protects speech. Its protections are strongest for speech that is obviously not factual, speech that no reasonable person would interpret as a statement of verifiable truth. Satire is the pinnacle of this protection. When you depict a public figure transforming into a giant mechanical dinosaur, no court will find that you are making a factual claim that could damage her reputation. When you depict a character literally locked in a closet, no court will find that you are asserting as fact that the real person is homosexual in a manner that constitutes defamation. The more absurd the depiction, the more clearly it is satire, and the more fully it is protected. South Park's extreme absurdity is not merely a comedic choice. It is a legal strategy. Every time the show makes a depiction more outrageous, more impossible, more obviously fictional, it moves further into the zone of absolute constitutional protection. For public figures specifically, the legal standard for defamation requires proof of actual malice, defined by the Supreme Court in New York Times v. Sullivan as knowledge that the statement was false or reckless disregard for whether it was true or false. But when the statement is that someone transforms into a giant robot, the question of truth or falsity is nonsensical. The statement is so obviously not an assertion of fact that the legal framework for defamation does not even apply. You cannot defame someone with a statement that no one interprets as factual. South Park exists in a legal space where its most extreme content receives the strongest protection. The second layer is temporal. South Park operates on a 6-day production cycle. This was documented in detail in the 2011 documentary special 6 Days to Air, which followed the production of a single episode from conception to broadcast. An episode is conceived on Thursday. It is written on Friday and Saturday. It is animated, voiced, and edited on Sunday through Tuesday. It is delivered to the network on Wednesday morning, typically just hours before its evening broadcast. The entire process from idea to broadcast occurs within approximately 144 hours. This speed has two legal consequences that are critically important for understanding the show's survivability. First, it means that by the time a potential plaintiff becomes aware of content that concerns them, that content has already been broadcast to millions of viewers. It has already been seen. It has already been discussed. It has already been shared on social media. It has already entered the cultural conversation. The fastest form of legal relief available, a temporary restraining order seeking to prevent broadcast, requires notice to the defendant, a court hearing, and a judge's decision. Even under emergency expedited procedures, this takes days minimum. By then, the episode has aired. You cannot unair television. You cannot unsee what has been broadcast. The legal system is simply too slow to prevent South Park from airing content before the content reaches its audience. Second, the production speed means that South Park can respond to events, including legal events, in near real time. If a lawsuit is filed on Monday, an episode about that lawsuit can be on the air by the following Wednesday. If a public figure threatens the show on Tuesday, that threat can be referenced on the following week's broadcast. The show moves faster than its adversaries. It can comment on attempts to suppress it before those attempts have concluded. It can make the suppression attempt into content before the suppression has succeeded. This creates a dynamic in which attacking the show feeds the show. Every action taken against it becomes material for the next episode. This is not merely demoralizing for adversaries, it is strategically paralyzing. How do you attack something that converts your attacks into ammunition? The third layer is corporate. South Park has been Comedy Central's most commercially significant program for the majority of its 29-year existence. It generated $500 million in a single streaming licensing deal. Its creators command $900 million contracts. The show's library is valued as a strategic asset by multiple publicly traded companies. When South Park faces legal action, it does not face that action as two individuals from Colorado defending themselves with personal resources. It faces it with the full institutional weight of Paramount Global, a company with a market capitalization measured in billions, a legal department employing hundreds of attorneys, and relationships with the most expensive and capable law firms in the country. When an individual plaintiff sues South Park, that plaintiff is not suing Trey Parker. That plaintiff is suing a corporation that can afford to litigate indefinitely, that has no financial incentive to settle unless settlement is cheaper than continued defense, and that has a strategic incentive to defend aggressively because settling one case invites additional cases. The corporate defense apparatus exists specifically to make suing South Park an unprecedented and unprofitable experience. For the plaintiff, the resources are allocated, the lawyers are retained, the strategy is predetermined. Individual plaintiffs without institutional backing cannot compete in this environment. They lack the resources for sustained litigation against the defendant that can spend more on legal fees in a week than the plaintiff can spend in a year. The fourth layer is strategic intention. Parker and Stone are not randomly provocative. Their targets are chosen with awareness of legal boundaries that is more precise than most audiences realize. They target public figures, not private individuals. They make obviously fantastical claims, not factual assertions. They use deliberate absurdity to ensure that no reasonable person could interpret their depictions as statements of fact. They do not allege specific criminal conduct or specific factual misdeeds that could be disproven. They depict characters doing obviously impossible things in obviously fictional settings. The legal significance of this targeting discipline is enormous. A private individual can bring a defamation claim under a negligence standard. A public figure must prove actual malice. The showing required for a public figure to win a defamation case against a satirist is so high as to be functionally impossible. The public figure must prove that the satirist knew their depiction was false, which is meaningless when the depiction involves a giant robot, or that the satirist acted with reckless disregard for truth, which is equally meaningless when no factual claim is being made. These four layers, constitutional, temporal, corporate, and strategic, operate as an integrated system. Remove any one and the show might be vulnerable. A slow production schedule would allow injunctions. Weak corporate backing would allow litigation costs to overwhelm personal resources. Imprecise targeting might occasionally cross into actionable claims. And without the First Amendment's protections for satire, the entire enterprise would be subject to prior restraint. But with all four operating simultaneously, the show occupies a legal position that is effectively unassailable through conventional mechanisms. The only attack that ever succeeded, the death threats in 2010, succeeded precisely because it was not conventional. It did not operate through the legal system. It operated through the threat of extra-legal violence. And even that success was partial and ultimately self-defeating, resulting in decades-long prison sentences for the people who made the threats. There is something worth pausing on here. something worth considering in the quiet of this moment before we reach the final entry. These 4 layers, this integrated defense system, did not emerge all at once. It was not designed on a whiteboard by attorneys and media strategists in 1997. It evolved. It was tested, layer by layer, across the successive confrontations we have already discussed. The NPAA battle in 1990 tested the commercial layer and proved that economic value overrides regulatory objection. The Streisand affair demonstrated the amplification dynamic. The Scientology confrontation tested the corporate layer and proved that indirect pressure through parent companies achieves at most temporary delay. The Brown Mark case tested and confirmed the legal layer through published federal precedent. The Muhammad crisis tested the absolute limit and identified the one scenario, physical threat, that partially penetrates the defenses. Each confrontation made the system stronger. Each failed attack confirmed a principle. Each legal victory established precedent that deterred future challenges. The show did not become legally invincible overnight. It became legally invincible through 29 years of iterative testing, through 29 years of opponents probing for weaknesses and finding none, through 29 years of published court opinions, public capitulations, and documented failures that collectively communicated a single message to every future potential adversary. This is not a fight you can win. This has been tried. This has been tried by the MPAA, by global celebrities, by one of the most litigious organizations on Earth, by a billion-dollar corporation with legitimate contractual claims, and by a nuclear-armed sovereign nation. All of them failed. What makes you think you will succeed where all of them did not? That accumulated history of failure is, in itself, the show's most powerful legal protection. Not any single court ruling, not any single constitutional principle. The fact that 29 years of consistent opposition have produced 0 lasting suppressions, that record is visible. It is public. It is available to every attorney who conducts research before advising a client whether to file suit against South Park. And every attorney who conducts that research arrives at the same conclusion. Advising the client to sue South Park is advising the client to spend money in exchange for nothing. It is malpractice to recommend an action with 0 historical probability of success. The fortress does not merely stand. It broadcasts the fact that it stands. Every failed siege becomes a warning to the next would-be besieger. The defenses grow stronger not through physical fortification, but through the accumulated evidence of their impregnability. This is why the legal challenges have become less frequent over time, despite the show becoming more provocative, not less. The deterrent is not subtle. It is a quarter century of consistent, public, documented failure by every entity that has tried. The 10th and final entry is not a lawsuit, not a regulatory action, not a corporate maneuver. It is a state-level ban imposed by the government of the most populous country on Earth. It represents the deployment of sovereign power, the power of a nation-state with 1.4 billion citizens and the world's second-largest economy, against a 22-minute animated comedy produced in a studio in Los Angeles. And it failed as completely as everything else on this list. On October 2nd, 2019, Comedy Central aired the 2nd episode of Season 23. The title was Banned in China. The episode follows 2 parallel storylines that arrive at the same thematic destination through different paths. In the first storyline, Randy Marsh travels to China to expand his marijuana business, to Gritty Farms. He quickly discovers that operating within the Chinese market requires absolute and total submission to the Chinese government's censorship demands. Every reference to any topic the government considers sensitive must be eliminated. Tibet cannot be mentioned. Taiwan's political status cannot be acknowledged. Tiananmen Square cannot be referenced. The Dalai Lama does not exist. Winnie the Pooh does not exist because the internet has compared him to President Xi Jinping, and the comparison is banned. Randy must not merely avoid these topics, he must actively participate in their suppression. He must self-censor reflexively, automatically, and completely. The price of access to the Chinese market is the total surrender of creative freedom. In the second storyline, Stan and his friends form a death metal band. A biographical film about the band is commissioned. An American studio is producing it, but the studio has ambitions for international distribution, including the Chinese market. A Chinese government representative is assigned to review the script. Every creative choice that could offend Chinese sensibilities is systematically removed. Every reference to death is removed because it is considered inappropriate. Every reference to rebellion is removed because it suggests political unrest. Every reference to individual expression is removed because it implies values incompatible with collectivism. By the end of the process, the biographical film about a death metal band contains no death, no metal, no rebellion, no individual expression, and no recognizable connection to its subject. It has been censored into meaninglessness. The episode aired on a Wednesday evening in the United States. It generated the response it was designed to generate. Within days, South Park was completely erased from the Chinese internet. The erasure was total. The show was removed from Baidu, China's dominant search engine, which processes approximately 80% of Chinese internet searches. It was removed from Bilibili, one of China's most popular video platforms, with over 300 million monthly active users. It was removed from Youku, another major streaming platform, most remarkably a search for South Park on Weibo, China's microblogging platform equivalent to Twitter, with over 500 million registered accounts, returned 0 results. Not 0 current results, 0 historical results. Among the billions of posts accumulated on the platform across years of operation, not one single mention of South Park remained visible. The show was not merely removed going forward. It was retroactively erased. Every historical post that had ever mentioned it was deleted or hidden. Every fan discussion, every clip sharing, every recommendation, every joke referencing the show, gone, as if it had never been discussed on the platform at all. This was not a legal action in any Western sense of the term. No court issued an injunction, no judge presided over a hearing, no plaintiff filed a complaint seeking damages. It was an administrative action by the Chinese government's internet censorship apparatus. The apparatus, sometimes called the Great Firewall, consists of technical infrastructure that monitors and controls internet traffic entering and circulating within China, supplemented by content moderation teams employed by every major Chinese internet company who manually review and remove content flagged by automated systems or government directives. A directive was issued, the directive was implemented, South Park ceased to exist within the Chinese internet. Parker and Stone responded on October 7, 2019. 5 days after the episode aired, with a statement posted to their official Twitter and Instagram accounts. The statement was formatted as an apology. Its content was the precise opposite of an apology. It read, in its entirety, "Like the NBA, we welcome the Chinese censors into our homes and into our hearts. We too love money more than freedom and democracy. She doesn't look like Winnie the Pooh at all. Long live the great Communist Party of China. May this autumn's sorghum harvest be bountiful. We good now, China?" The NBA reference was calculated and topical. Days before South Park was banned, Houston Rockets general manager Daryl Morey had posted a tweet expressing support for pro-democracy protesters in Hong Kong. The tweet generated fury from the Chinese government and from Chinese commercial partners. The NBA's response was widely criticized in the West as capitulatory. The league issued a statement expressing regret that Morey's views had offended. Individual players, coaches, and executives declined to comment on Hong Kong or appeared to align with China's position. Hundreds of millions of dollars in Chinese broadcast revenue, merchandise sales, and sponsorship deals hung in the balance. The NBA chose money. Parker and Stone chose mockery. The asymmetry that made this choice possible is important. The NBA had billions of dollars at stake in the Chinese market. South Park had almost nothing. The show's audience was overwhelmingly American and European. Its revenue derived from domestic cable ratings, domestic streaming deals, and domestic advertising. China represented at most a marginal opportunity for future expansion. By banning South Park from China, the Chinese government was taking away something that barely existed. The economic leverage that made the NBA capitulate had no equivalent in this situation. Parker and Stone could afford to mock Beijing because Beijing could not threaten anything they valued. South Park remains banned in China in 2026. The ban has never been lifted. No formal statement explaining the ban has ever been issued by the Chinese government. The Chinese government does not explain its censorship decisions publicly. It simply acts and expects compliance. From the perspective of a Chinese internet user who does not employ circumvention tools such as VPNs, South Park does not exist. It has no presence on any Chinese platform. It cannot be searched. It cannot be discussed. It cannot be referenced. It has been administratively deleted from the digital experience of over 1 billion people. And yet the ban accomplished nothing of consequence. South Park's revenue was unaffected. Its production schedule was unaffected. Its audience growth was unaffected. If anything, the ban increased the show's profile in Western markets because the story of the ban generated international news coverage. Every major news outlet in the English-speaking world reported on it. Every report mentioned the show by name. Every article described its content and its history of provocation. The ban functioned as free advertising in the markets that actually matter for the show's economics. The Chinese ban is the purest, most distilled expression of the principle that has governed every single entry on this list. It is the Streisand effect elevated to geopolitical scale. The government of 1.4 billion people attempted to suppress a television show, and in doing so generated more Western media attention for that show than any marketing campaign could have produced. The attempt to make it invisible made it more visible. The attempt to silence it gave it a bigger megaphone. The attempt to erase it wrote it into history more permanently than any episode alone could have. There is another dimension to the China ban that deserves attention. It is the only confrontation on this list in which South Park's adversary has not, in some sense, been damaged by its own action. The MPAA was embarrassed when the film it tried to suppress earned an Oscar nomination. Streisand's name became a byword for counterproductive suppression. Scientology's decision not to sue was widely interpreted as an admission that it could not survive discovery. The Muhammad threats resulted in federal convictions and decades of imprisonment. Each adversary paid a price for their opposition. China paid no price. The Chinese government was not embarrassed by the ban. It was not criticized within China because criticism of government censorship is itself censored. It did not lose money because it had no financial stake in South Park's success. It did not suffer reputational damage within its own borders because its domestic media did not report on the ban sympathetically. The ban cost China nothing and achieved its domestic objective perfectly. Within China, South Park does not exist. The erasure was complete and has remained complete for 7 years. But here is the distinction that matters. China's objective was not to destroy South Park. It was not to end the show's production. It was not to prevent the show from airing. Its objective was limited and domestic, to remove the show from Chinese internet platforms. And it achieved that limited objective completely. But that limited objective was, from South Park's perspective, irrelevant. The Chinese market was never significant to the show's business. Removing South Park from China is like removing a book from a library that none of the book's readers ever visit. The removal is real. The effect on the book's readership is zero. This is why the China ban, despite being imposed by the most powerful single entity to ever act against South Park, does not represent a genuine threat. A genuine threat requires the capacity to impose meaningful consequences. Consequences require leverage. Leverage requires something to target values that the adversary can threaten. China had no leverage over South Park because South Park had nothing in China worth protecting. The ban was an exercise of absolute power that produced zero consequence for its target. It was a government spending state resources to suppress a television show that did not care whether it was suppressed in that market. Compare this to the only successful suppression on the list. The Muhammad threats in 2010 succeeded because they targeted something the show's distributors valued: the physical safety of their employees. The threat was credible because a filmmaker had actually been murdered under comparable circumstances 6 years earlier. The leverage was real because the consequence was real. China's ban lacked this. It threatened nothing that mattered to anyone involved in producing or distributing South Park, and so it achieved nothing that mattered to them. The lesson is precise. To threaten South Park effectively, you must be able to threaten something the show values. You must be able to impose a consequence that cannot be absorbed, cannot be converted into content, cannot be monetized through publicity. The MPAA could threaten distribution but was overruled by commercial pressure. Scientology could threaten exposure but feared counter-exposure more. Brownmark Films could threaten damages but could not survive a motion to dismiss. The only entity that ever found the correct target, the physical safety of human beings, achieved the only lasting result. Everything else was theater. And even that success came at a price so extreme that no rational actor would repeat it. 25 years in federal prison. That is the cost of successfully threatening South Park. That is the price of the only successful suppression in the show's history. If you are unwilling to spend the rest of your life in a cell, you cannot silence this show. That is the final, definitive statement about its legal position. Its existence is so thoroughly protected that the only attack vector requires accepting a lifetime sentence as the price of partial success. Sit with that for a moment. A television show has achieved a position in the American legal landscape so secure that the only way to suppress it requires commission of a federal crime carrying a multi-decade sentence. The show is not merely legally protected, it exists beyond the reach of any legal challenge. The only threats that register are illegal ones. And illegal threats are self-defeating because they result in the imprisonment of the people who make them. The system is hermetically sealed. There is no entry point that does not destroy the entity attempting entry. Consider the full scope. Stand back and view the complete picture. The Motion Picture Association of America spent 6 months trying to prevent a film from reaching theaters. The film earned 4 times its production budget and received an Academy Award nomination. Barbra Streisand objected to her depiction and became permanently associated with the futility of suppression. The Church of Scientology considered suing and determined that the cost of institutional exposure made silence the safer choice. Tom Cruise deployed corporate leverage to delay a rerun by a few weeks, a delay that drew more attention to the episode than the rerun itself would have generated. Isaac Hayes was involuntarily removed from the show by his own religious organization while he was physically incapacitated, an act that has since been publicly exposed and that deepened sympathy for the show. The show invented a legal term that actual lawyers use in actual courtrooms. A federal judge determined that the show's creative method was so clearly protected that a copyright claim against it did not merit the expense of a trial. Religious extremists issued death threats and achieved partial censorship of 2 episodes at the cost of cumulative decades in federal prison. An individual filed a copyright claim based on dubious evidence and was resolved without consequence. 2 of the largest media companies in the world went to war over who gets to profit from the show, demonstrating that its value exceeds what most corporations earn in a decade. And the government of China erased it from the internet of 1.4 billion people without measurably affecting its audience, its revenue, or its creative output. Not one of these entities achieved its fundamental objective. Not one succeeded in altering the show's long-term trajectory. Not one managed to make Parker and Stone produce different content, target different subjects, adopt a different tone, exercise more caution, or demonstrate anything resembling contrition for past provocations. The show in 2026 is the show in 1997. Same targets, same tone, same willingness, same refusal. And that refusal is the strategy. That is the thing every adversary misunderstands. The refusal to modify is not stubbornness. It is not artistic ego. It is not recklessness. It is the carefully maintained architecture of legal invincibility. The moment you modify in response to pressure, you establish that pressure works. You teach the next adversary what to do. You create a template. You invite escalation. You make yourself vulnerable not just to this threat, but to every subsequent threat that follows the same model. By never modifying, by converting every threat into content, by responding to every pressure with escalation rather than retreat, Parker and Stone broke the feedback loop that makes creative suppression a rational strategy. There is no return on investment in threatening South Park. The threat becomes an episode, the lawsuit becomes a joke, the ban becomes a press release, the censorship becomes proof of relevance. There is nothing to gain and everything to lose. And after 29 years of consistent demonstration, this lesson has been learned by most potential adversaries. The legal challenges have become less frequent over time. Not because the show has become less provocative, because potential challengers have observed 29 years of other challengers failing and have concluded that they too would fail. Return now to the beginning. February of 2023, Warner Bros. Discovery versus Paramount Global. $500 million. A single word. Episode or movie? That is the legal question. But the question that matters, the question that emerges when you view this full trajectory from 1998 to the present, is different and larger. Here is a show that has been targeted by the MPAA, by Barbra Streisand, by the Church of Scientology, by Tom Cruise, by religious extremists who explicitly promised murder, by a federal copyright plaintiff with a legitimate claim, by an individual with a dubious claim, by $2 billion corporations fighting over distribution rights, and by the government of the People's Republic of China. And the only legal battle that ever drew genuine blood, the only one that involved real financial uncertainty and the genuine possibility of a substantial adverse judgment, was 2 corporations fighting over which of them gets to sell the show to you. Nobody has ever successfully argued that South Park should not exist. Nobody has ever prevailed on the claim that the show violates anyone's rights, infringes anyone's copyright, or exceeds the bounds of protected speech. The only argument that ever gained legal traction, the only one that ever produced genuine uncertainty and required genuine adjudication, was about money. About who gets to profit, about which corporate entity holds which distribution rights, about how to divide the revenue generated by content that everyone agrees should continue to be produced. That tells you everything. It tells you that South Park's existence is not in question, only its distribution. It tells you that the show's right to say what it says is not contested in any court, only the right to sell what it says. It tells you that the legal system, after 29 years of testing, has determined conclusively that this show is protected speech, that its creators are within their rights, and that the only remaining legal questions involve the commercial arrangements between the corporations that distribute it. 29 years of continuous production, 10 major legal confrontations, the Motion Picture Association, Barbra Streisand, the Church of Scientology, and Tom Cruise. The show's own legal vocabulary entered permanently into jurisprudence. A copyright plaintiff defeated before trial, religious extremists imprisoned for their threats, An individual plaintiff dismissed without consequence. 2 corporations fighting over $500 million in streaming revenue. And the government of China failing as completely as everyone else. 0 losses. 0 losses across 29 years. 0 modifications to creative direction. 0 concessions to external pressure. 0 court-ordered suppressions. 0 successful claims of copyright infringement. 0 successful claims of defamation. 0 instances of the show altering its behavior in response to a legal threat rather than escalating its behavior in response to that threat. These numbers need to be placed in context. South Park has aired over 327 episodes and multiple films and streaming specials across its lifetime. It has depicted thousands of real people, referenced thousands of copyrighted works, made thousands of statements that could theoretically be characterized as defamatory, by targets with sufficient motivation and resources to file suit. The number of potential legal claims that could theoretically have been brought against the show across 29 years, if every possible theory of liability were explored by every possible plaintiff, is essentially incalculable. It runs into the thousands, perhaps the tens of thousands. And of those thousands of potential claims, 10 materialized into genuine confrontations. And of those 10, 0 succeeded. The ratio matters. It tells you something not just about the show's legal defenses, but about the rational calculation performed by potential adversaries. For every entity that did challenge South Park, there were hundreds that considered it and decided against it. For every lawsuit filed, there were dozens that were contemplated in the offices of entertainment lawyers and abandoned before the complaint was drafted. The deterrent effect of the show's track record extends far beyond the 10 cases on this list. It encompasses every case that was never filed, every complaint that was never drafted, every potential plaintiff who looked at the history and concluded that the economics of litigation made the attempt irrational. You cannot see those unfiled cases. You cannot count the lawsuits that never happened. But they represent the majority of the show's legal victories. The greatest legal triumph is not winning in court. It is making the fight so clearly futile that nobody bothers to show up. South Park achieved that status years ago. The 10 confrontations on this list are the exceptions. The norm, the daily reality of the show's existence, is that people who are mocked by it, who are parodied by it, who are depicted in it without their consent and without flattery, simply absorb the mockery and move on, because they have seen what happens to people who fight back. They have seen the pattern. They have seen the Streisand effect. They have seen the amplification dynamic, and they have made the rational choice to accept ridicule rather than amplify it. This is the ultimate victory. Not survival, deterrence. Not winning legal battles. Preventing them from being fought. The show has not merely built a fortress. It has made the fortress so visibly impenetrable that armies no longer march toward it. They see it from a distance, assess its defenses, and turn around. That is power. Not the power to win a fight. The power to end fighting by making victory so obviously unattainable that no rational actor engages. And underneath all of it, beneath the legal layers and the economic protections and the temporal advantages and the strategic discipline, there is something else. Something simpler. Something that no legal analysis can fully capture. Parker and Stone genuinely do not care. This is not performance. It is not strategic indifference calculated for its legal benefits. It is actual, authentic, psychological indifference to the opinions of adversaries. They do not fear Barbra Streisand. They do not fear the Church of Scientology. They do not fear Warner Brothers. Discovery's legal department. They do not fear the government of China. Their creative decisions are not made through a filter of concern about potential legal consequences. They make the show they want to make. If someone objects, that objection becomes material. If someone sues, that lawsuit becomes a story. If someone bans them, that ban becomes a credential. This indifference, this genuine psychological immunity to external opinion, is the foundation on which all 4 legal layers rest. Without it, the legal protections would be academic. A creator who feared legal challenge would self-censor before the legal system ever became involved. A creator who worried about corporate displeasure would moderate before the corporation ever needed to apply pressure. The legal defenses matter only because Parker and Stone produce content extreme enough to trigger them. And they produce content that extreme because they genuinely do not care whether it triggers them. The indifference comes first. The legal protections merely ensure that the indifference can be sustained without personal consequence. There is a word for this in psychology. Learned fearlessness. Not the absence of fear at the beginning, but the absence of fear developed through repeated exposure to threats that did not result in harm. Every legal threat that failed to produce consequences taught Parker and Stone that the next threat would also fail. Every confrontation survived made the next confrontation less frightening. After 29 years, after 10 major confrontations and 0 losses, The fear response has been entirely extinguished. There is nothing left to threaten them with. Money? They have $900 million. Reputation? Their reputation is built on provocation. Access? They need no one's permission to produce content. Distribution? Multiple billion-dollar companies compete for the right to distribute their work. There is no lever. There is no pressure point. There is no vulnerability that an adversary can exploit. The system is closed. The fortress has no gate. And that fearlessness is self-reinforcing. It does not diminish over time. It strengthens, because each year that passes without a successful legal challenge adds another year to the track record. Each episode that airs without consequence confirms the thesis. Each new target that does not sue, each new provocation that does not result in an injunction, each new controversy that generates press attention rather than legal jeopardy, adds another data point to the overwhelming pattern. The pattern is not merely observed, it is actively maintained through deliberate creative choices that test and reconfirm the defenses every single week. Consider what this looks like from the perspective of someone who has just been depicted on South Park in an unflattering manner. You are a public figure. You have resources. You have attorneys. You have been shown on national television doing something humiliating, obscene, or absurd. You want to respond? You want to file a lawsuit? You want to suppress the episode? You want to punish the people who did this to you? What do? You call your attorney. Your attorney researches the matter. Your attorney discovers that the MPAA could not suppress this show, that Barbra Streisand could not suppress this show, that the Church of Scientology, one of the most litigious organizations in human history, chose not to sue because the cost was too high, that a federal judge threw out a copyright claim on a motion to dismiss without even allowing it to proceed to discovery, that 2 Fortune 500 companies are currently spending millions of dollars fighting over who gets to distribute this show, which tells you exactly how much corporate legal firepower will be deployed against you if you file suit. Your attorney tells you all of this. Your attorney shows you the published case law. Your attorney calculates the cost of litigation against a defendant with unlimited resources and a perfect track record. Your attorney advises you not to file, and you do not file because you are rational, because you understand cost-benefit analysis, because you see 29 years of consistent failure by adversaries more powerful than you. And so the show continues, it depicts the next target, and the next target goes through the same calculation and arrives at the same conclusion, and does not file. The cycle perpetuates itself. The deterrent strengthens with each repetition. The fortress grows more imposing with each army that camps outside its walls, surveys its defenses, and marches home without attacking. This is the final state of the system. Self-perpetuating legal invincibility through accumulated deterrents, not legal invincibility granted by a single ruling or protected by a single constitutional provision. Legal invincibility earned through 29 years of unbroken successful defense, visible to every potential future adversary, communicating a single clear message: do not bother. You will spend money. You will spend time. You will draw attention to the show. You will lose. And the show will make an episode about your loss. There are shows that have been canceled by controversy. There are shows that have been altered by corporate pressure. There are shows that have been softened over time, their edges rounded by accumulated legal caution, their creators growing timid as the targets grow more powerful and the stakes grow higher. South Park is not one of those shows. It has moved in the opposite direction. It has become more extreme over time, not less. It has targeted more powerful figures over time, not weaker ones. It has taken greater creative risks with each passing season, because each passing season confirms that the risks do not result in consequences. The trajectory is upward, the provocation escalates, and with each escalation that goes unpunished, the next escalation becomes more likely and the potential consequences become less credible. You are witnessing, across the span of this narrative, the creation of something genuinely unusual in the history of media. A creative work that has achieved, through sustained and deliberate practice, a position of legal and cultural immunity that no other program has replicated. Others have tried, others have been controversial, others have been sued, but none have compiled this specific combination of constitutional protection, temporal advantage, economic indispensability, strategic precision, and psychological fearlessness operating simultaneously across 3 consecutive decades without a single loss. This is not merely unusual. In the history of American television, it may be unique. And so the show continues into its 30th year, into whatever targets and whatever controversies and whatever legal challenges the next decade may bring. Continuing because it cannot be stopped. Continuing because stopping it would require a mechanism that does not exist within the American legal system. Continuing because every entity that has ever tried to end it has failed, and that history of failure is now so long, so consistent, and so public that attempting to add to it is an act of irrationality. Continuing because Parker and Stone will make the show until they choose to stop, and nobody, not a ratings board, not a celebrity, not a church, not a corporation, not a sovereign nation has the power to make that choice for them. And when they do eventually choose to stop, whenever that day comes, it will be their choice, made freely, made without external pressure, made on their own timeline. The show will end not because it was silenced, but because its creators decided they were finished. That distinction between being silenced and choosing silence, between being defeated and choosing to walk away, is the distinction that 29 years of legal survival has protected. The show remains on the air not because it has to be. It remains on the air because it can be. Because nothing has ever successfully argued otherwise. Because the legal right to exist and to say what it says has been tested and confirmed so many times that the testing itself has become redundant. The question is no longer open. The answer is no longer uncertain. South Park has the legal right to exist, to say what it says, to target who it targets, and to continue indefinitely. That right is settled. Completely. Permanently. Beyond reasonable dispute. There is a lesson in that record if you are still awake to hear it. Not about law exactly, not about comedy exactly, about the intersection where the two meet. About what happens when a creative work positions itself so precisely within the protections of the First Amendment that attacking it becomes more costly than tolerating it. About what happens when suppression generates amplification so reliably that the rational choice is always to leave it alone. About what happens when 29 years of consistent behavior teaches every potential adversary, through 29 years of consistent failure by their predecessors, that the fight is not worth having. South Park understood this before anyone tried to articulate it, before the Streisand effect had a name, before fair use jurisprudence evolved to match the digital age, before streaming wars made content catalogs worth hundreds of millions, before social media turned every controversy into free publicity. The show understood, from its very first season, from the very first time someone told it not to say something, that the safest place to stand is precisely where everyone tells you not to stand. That the most protected speech is the speech everyone wants to silence. That the strongest legal position belongs to the work everyone wishes did not exist. That is where South Park has always stood. That is where it stands now. 29 years. Unchanged. Undefeated. Still saying what nobody else will say. Still targeting who nobody else will target. Still standing exactly where everyone told it not to. If you enjoyed this, subscribing helps more than you would think. Thank you for staying. Sleep well.